We are on the record. This is the state of North Dakota versus Travis Carlson. The file number is 03-2025-CR93. The record should reflect that Mr. Carlson is present by Zoom. Mr. Carlson, your mic is on mute. Can you hear me?
Yes, Your Honor, I can hear you.
Okay, Ms. Martinez, can you hear me?
Yes, Your Honor, I can hear you. Thank you.
And Ms. Bromke, Mr. Bromke, can you hear me?
I can, Judge. Can you hear me?
Yes. And at this point, I know there's media and other folks on the line, so what's going to be happening here today is I'm going to be going through the criminal information, and I will be going through the basic rights that Mr. Carlson has, and then we will have a discussion about what kind of bond should be set. So at this point, Mr. Carlson, there are several counts in the criminal information. I have 13 different counts, and I'm going to go through each one of them so that it's on the record. Count one, in relevant part, is that on the 9th day of April 2025, the defendant knowingly made an arrest of a tribal member, TB, in Indian country for alleged felony offense without Bureau of Indian Affairs authority. The defendant then falsified his statement of probable cause, claiming he had concurrent jurisdiction. With regard to this charge, Mr. Carlson, do you understand what you're being charged with?
Yes, Your Honor.
Okay, this is a C felony, and the maximum penalty for a C felony is 5 years in jail and a $10,000 fine. Count two is that on the 9th day of April 2025, the defendant only made an arrest of a tribal member, THB, in Indian country for alleged felony offenses without Bureau of Indian Affairs authority. The defendant then falsified a statement of probable cause, claiming he had concurrent jurisdiction. This also is a C felony. Do you understand what you're being charged with?
Yes, Your Honor.
Count three, tampering with public records on or about the 27th day of May 2025. The defendant falsified his investigative report by knowingly arresting two tribal members for alleged felony offenses in Indian country, transporting them to tribal court for an extradition hearing, illegal impossibility, claiming he was exercising concurrent jurisdiction before transporting to the Lake Region Law Enforcement Center off the Indian reservation and subsequent incarceration. This also is a C felony. Do you understand what you're being charged with?
Yes, Your Honor.
Count four, official oppression. On or about the 19th day of April 2025, the defendant illegally arrested TB, an enrolled member of alleged burglary charges. The defendant illegally detained her in jail facility off the reservation. This is an A misdemeanor. Maximum penalty is 360 days in jail and a $3,000 fine. Do you understand what you're being charged with here?
Yes, sir.
Count five, on or about the 9th day of April 2025, the defendant illegally arrested THB, an enrolled member of alleged burglary charges. The defendant illegally detained her in jail facility off the reservation. This is an A misdemeanor. Do you understand what you're being charged with?
Yes, sir.
Count six, official oppression. On or about the 30th day of September 2024, the defendant illegally detained, mistreated, and infringed on a personal rights of DD, a juvenile passenger in a motor vehicle. This is an A misdemeanor. Do you understand what you're being charged with?
Yes, sir.
Count seven. On the 7th day of August 2024, the defendant conducted a traffic stop on a highway at night that served no legitimate purpose. KA was illegally detained and questioned about a matter unrelated to the stop. This is an A misdemeanor. Do you understand what you're being charged with?
Yes, sir.
Count 8. On or about the 17th day of April 2025, the defendant refused to identify a key witness, another unknown law enforcement officer, to an arrest incident for prosecution purposes in violation of North Dakota Century Code 440406. Unidentified or unrevealed witness was a person from outside Benson County who removed an occupant from a motor vehicle and detained her while the defendant searched the motor vehicle. This is an A misdemeanor. Do you understand what you're being charged with?
Yes, sir.
Count 9, public servant refusing to perform a duty. On or about the 14th day of April 2024, the defendant, as an investigating officer of a reported break-in and burglary of the Dakota Spirits Bar, has failed to make or file or present any report or conclusion of the burglary after several requests by the state's attorney. This also is an A misdemeanor. Understand what you're being charged with.
Yes, sir.
Failure to appear as a witness or produce information. On or about the 20th day of May 2025, after receiving subpoenas, the defendant failed to appear for a preliminary hearing in criminal case 03-2025 CR 48. This is an A misdemeanor. Do you understand what you're being charged with?
Yes, sir.
Count 11 is disorderly conduct. On or about the 24th, on May 24, 2023, or October 29, 2023, the defendant, as a supervisor and field training officer, caused AJ, in her role as a law enforcement officer, to be harassed, alarmed, and annoyed by the defendant's repeated sexual innuendos. This is a B misdemeanor. Maximum penalty is 30 days in jail and a $1,500 fine. You understand what you're being charged with?
Yes, sir.
Count 12 is another disorderly conduct charge. On or about the 25th day of March 2025, the defendant's sexual harassment alarmed and annoyed NL in Benson County by coming to her place of work in a deputy sheriff uniform and grabbed NL from behind on the shoulders. On or about the 28th day of March 2024, the defendant, following a domestic event at NL's home, instructed NL to shut off her surveillance cameras as the defendant would be stopping by the home of NL to give her hugs to NL. This is a B misdemeanor. Do you understand what you're being charged with?
I do.
Count 13, disorderly conduct. On or about the 9th day of July 2024, the defendant, a male, followed HS, a detained female, into a woman's bathroom wherein the defendant stood with his body camera recording while HS obtained a urine sample for drug testing. HS was alarmed, harassed, and annoyed at the demand and expectation of the defendant that NL provide a urine sample under these conditions. This also is a B misdemeanor. Do you understand what you're being charged with?
Yes, Your Honor.
Now, with regard to the felony charges, you have the right to a preliminary hearing. That is a probable cause determination hearing. So what happens at that hearing is the state brings in a witness to testify, and if the court finds there is probable cause, then you would be arraigned. By entering a not guilty plea to a felony charge, you would have the right to a jury trial. You would have the right to confront witnesses that would testify against you. You understand these rights?
Yes, Your Honor.
With regard to a misdemeanor, you also have the right to a jury trial. You also have the right to confront witnesses that would testify against you. You understand?
Yes, Your Honor.
And on all criminal charges, the state must prove you guilty beyond a reasonable doubt, and they must prove you guilty without you testifying. They can never force you to testify at trial. You understand?
Yes, Your Honor.
If we do go to trial on these cases, then you would have the opportunity to testify only if you wanted to do so. You understand?
Yes, Your Honor.
If you did testify, then the state would have the opportunity to cross-examine you or question you. You understand?
Yes, Your Honor.
And at this point, I'm not going to go further with regard to your rights and with regard to the charges. What I'm going to do now is ask the state's attorney, well, first off, the state's attorney, since you are you acting on behalf of the Benson County State's Attorney?
Yes, Your Honor.
Okay. So what is your recommendation as to bond?
Thank you, Judge. We're requesting $15,000 cash, no contact with any of the victims, no contact with the Benson County Courthouse, which houses the Sheriff's Department, stay off the Spirit Lake Nation Reservation, and GPS bracelet monitoring at the defendant's expense. The basis for these recommendations is, in addition to the allegations of substantial misconduct against individuals, sexual harassment and abuse of law enforcement authority that are contained in the information, Mr. Carlson presents what the state believes is a unique flight risk, in the sense that whenever he is or gets close to being held to account for bad actions he's taken as an officer, he just goes somewhere else to start the process over again. He's not some local cop who just, aw shucks, had his own way of doing things and some people didn't like his locker room talk. He has been what criminal justice academics call a wandering cop for the past decade, if not longer. His history of official misconduct goes back at least as far as 2014, when he was fired from the Belfield Police Department after admitting to having sex with a woman in his patrol car while on duty. After he lost his North Dakota peace officer's license, my understanding is that he bounced around South Dakota and Minnesota until his post-board reinstatement happened for North Dakota a few years ago. He's currently not licensed as a peace officer in Minnesota. As to the offenses that don't involve named victims, immediately before he was hired by Benson County, Mr. Carlson was the chief of police for the city of Harvey. And since he left, the current chief of police literally cannot forward offenses for prosecution that occurred during Mr. Carlson's tenure as police chief, both because he's on the Brady list and also because he didn't do his job properly as a custodian of records and an office manager. Since those didn't occur in Benson County, they're not brought today. Mr. Carlson's crimes represent not just offenses against the Spirit Lake Nation reservation community, but against the people of the state of North Dakota, who have some entitlement to the expectation that uniformed officers are going to treat them with dignity and professionalism. So on that basis, the state submits that a high cash bond and substantial conditions are appropriate. Thank you.
Okay, defense counsel, you may make your argument.
Your Honor, my client's not been charged with a criminal allegation previously. He does have ties to the community. He has lived there for 5 years. He has a home, a residence that he owns. He has full custody of his 11-year-old daughter, whom he supports as the sole provider. He has contacts to the area in that his mother lives in Brainerd, and Mr. Carlson has ties going back to Brainerd. He graduated from high school there and then attended college. He does also have high blood pressure. I'm concerned that he's not had his blood pressure medication. Pretrial services evaluated him and found him to score at a 1. I've not seen GPS on a case like this before. The law indicates that even if he were to be convicted, this is probably a presumptive probation case. We would ask for 5,000, 10%, or 5,000 PR would actually be more appropriate in compliance with pretrial services. Mr. Bromke makes an argument that I think is getting a bit ahead of himself here. He is talking about my client as though he's already been convicted. And that is not the case. He's innocent until proven guilty. Mr. Bromke knows he has an audience with the media here, and that's just very unfortunate. We would ask for 5,000, all PR in compliance with pretrial services.
Do you know whether your client is still employed by the Benson County Sheriff's Office?
Your Honor, it's my understanding they disappeared the sheriff 2 days ago, and they brought these charges against Mr. Carlson yesterday, and so he does not have a job there any longer. I don't know if anybody from the sheriff's office has a job there any longer.
That is incorrect, Your Honor. The sheriff of Benson County tendered his resignation today. I don't know on what basis Ms. Martinez is stating that.
Okay, well, is Mr. Carlson still employed by the Sheriff's Department? know.
To my knowledge, no, but
Okay. Mr. Carlson, do you know whether you're employed by the Benson County Sheriff's Department or not?
Do not, sir.
You're not?
I do not know, sir.
You don't know? Okay.
Correct.
my understanding from the individual who is going to be taking over for the Benson County Sheriff's Department is that Mr. Carlson's services will not be retained.
Okay, at this point, I'm making the assumption that he's not employed. At this point, I'm assuming he's possibly still licensed as a peace officer. Would that be accurate?
I don't know that they've processed a revocation. I assume that the post board ordinarily waits until after a conviction is entered if criminal charges are forwarded, but I could be wrong since he has previously had that authorization pulled.
Okay. At this point, I'm going to set bond at $10,000 cash or surety. As a condition of probation, Mr. Carlson cannot work as a law enforcement officer. Or not a condition of, as a condition of release. He is not authorized to work as a licensed peace officer in the state of North Dakota. He is not to leave the state of North Dakota. And I do want him on a GPS monitor, and he's to be on home detention let's put it at, he can be on home detention from 8 p.m. to 7 a.m. in the morning. Are there any other, and certainly no contact with the alleged victims in this case. And at this point, I'm asking the state's attorney to make sure that the defense attorney has all those names so that it's clear to Mr. Carlson that he's not to have any contact with those folks except through defense counsel.
Understood.
Okay. Ms. Martinez, is there anything else that you wish the court to address?
Your Honor, I just want to make sure that I understand. So if he posts $10,000 cash, he is still required to essentially be incarcerated at home pending trial?
Yep. Cash or surety. Let's make it $10,000 cash or surety. And he's to be at home in the evening. GPS.
I've just never heard of that kind of condition, Your Honor, so it took me a bit by surprise.
Okay, well, I've put people on home detention when I felt it appropriate. So again, on GPS and on home detention. And at this point, Mr. Carlson, if the court becomes aware through the state that you're trying to make contact with any of these folks, there will be a warrant for your arrest.
Yes, Your Honor.
Is there anything else we need to address?
Your Honor, did you want him to comply with pretrial services as well?
Yes, I want him to work with pretrial services.
Okay, thank you.
Okay, I want pre-trial services to be involved in the case. If nothing else.
Well, Your Honor, just briefly, in the event that for whatever reason his bond conditions are modified down the line, I would just reiterate the state's request that he not have contact with the Benson County Courthouse or the Spirit Lake Nation Reservation.
At this point, I don't believe he lives on the Spirit Lake Nation, so I guess I can put that condition on. He's not to be on the Spirit Lake Nation, and I'm just wondering, what's your concern about him being at the courthouse?
Our concern with respect to the Benson County Courthouse, specifically the Benson County Sheriff's Department, is as a person who previously had some supervisory authority there. We don't want him having any access to official records in any capacity or the opportunity to get in contact with them.
Okay, he's not to have any contact with the courthouse in Benson County except through his counsel. Okay?
Thank you, Judge.
If there's nothing else, we're going off the record. Thank you.
Thank you, Your Honor.